Okay.
My lord.
No, straight away come to the best point. Now, what is the best point you have?
My lord.
Yes,
Honestly-
straight away go there.
My lord.
Why it should be revised? Why the
My
court should interfere?
My lord. Before that, lordship,
Deposition copy rakhi
lordship.
Yes. Then straight away refer to the judgment,
My lord.
how it has evaluated the presented, whatever was presented.
My lord. Your lordship, the evidence.
Here, there are two judgments.
My lord. No.
First by the JMFC.
My lord. Your
Okay.
lordship, the informants of the petitioner before lordship.
Yes.
Originally, the FIR was registered, and the allegation in the FIR is that the accused person has set the house of the petitioner on fire.
Arson. So it's a. So how did it was investigated by the police?
My lord, no, first of all, the final form has been submitted. Thereafter,
Complaint dele tapare 1cc hela,
My lord.
1cc for investigation hela.
My lord.
Investigation re kon present kale prosecution. What was the evidence?
My lord, the PW3 and PW5 are the eyewitnesses, and PW2 and PW4 they are the occurrence witness, lordship. The learned trial court has acquitted the accused on only
3-5 state janto jodi eyewitness you have.
My lord.
Yes. Page 10 para 9.
My lord. I have the deposition copy, lordship. I am placing that.
How the court has first you go, the court has evaluated.
My lord.
Then you go to the deposition. Then you can correlate whether the court has evaluated correctly or not. Because I'll be relying on you as far as the deposition is concerned. I don't have deposition copy. Since you are having
permission, I have the certified copy. I can produce.
No.
I'm placing page 10, lordship, paragraph 9.
PW3 claims to be an eyewitness.
PW3 claims to be an eyewitness to the occurrence of this case. He has
Then go
specific.
slowly. Then because that's the statement.
My lord.
He has specifically stated, yes.
My lord. He has specifically stated in his evidence that hearing the shout of the informant, when he woke up and rushed to the house of the informant, he saw the accused person fleeing away from the spot, and dwelling house of the informant was burning in fire.
Stop there.
My lord.
Then go to the PW3's deposition.
My lord.
See that.
Your lordship, in the deposition, I am placing the subpara 2. I know the informant as well as the accused person of the case on 18.
PW1 ru padi dunanti. Apana para sorry, para 1 ru padi dunanti.
My lord. The deposition of the witness number PW3 for prosecution. Therefore, the age has been numbered in the first paragraph. I know the informant as well as all the accused person of the case on 18/11/2008, 19/11/2008 at the night at about 1 p.m. in the house of the informant. Incident of this case took place in the night of occurrence. While I was asleep, hearing the shout of the informant, I woke up, and when I rushed to the house of the informant, I saw the dwelling house of the informant burning on fire, and also I saw the accused person fleeing away from the spot. The accused Robbie.
Stop there. You have to be very precise. Very precise. So exactly the verbatim the court has reproduced the evidence. Then how he is an eyewitness? He's not an eyewitness. Then come to the 5W5. At best, he is an immediate post-occurrence witness. Again, one cannot say because it's a case of burning. So when it started burning, there was a halla and it was dead of the night. So he runs out. It's very natural.
My humble submission is, though the learned court below has recorded the deposition, exact deposition in the judgment, the finding is that the PW1, the evidence of the PW3 has not been corroborated by PW1 and 2, lordship. PW1
That's
is
contradiction part.
My lord.
That is contradiction part. But first you have to evaluate whether PW3 is an eyewitness, PW5 is an eyewitness. Then para 11, the same page, page 11, para 11 of the judgment.
PW5, who claims to be an eyewitness to the occurrence, has stated in his evidence that hearing the shout of the informant, when he woke up and rushed to the house of the informant, he saw the house of the informant was burning with fire and the accused person fleeing away from the spot.
Identical. Then now check
PW.
Now check PW5.
My lord.
Deposition.
Here also, Lordship, I know the informant as well as the accused person.
Yes.
On 18/11/2008, at about 1 p.m. in the house of the informant, in the village Ontario, incident of the case took place in the night of the occurrence. While I was asleep, hearing the sound of the informant, I woke up. When I rushed to the house of the informant, I saw the house of the
Same.
same, Lordship.
Yes. Then you go to the contradiction part.
My Lord.
Where
The
contradiction, why? The problem is that PW 1, 2, 3, and 5 all have been produced by the prosecution.
My Lord.
So if there is contradiction,
My Lord.
then it affects the prosecution case. Yes.
Here, Lordship, my Lordship may kindly see page 15 of the judgment, Lordship, paragraph
please.
13.
Yes.
The finding of the landlord.
Yes.
In view of the above noted discussion, I am on the consideration opinion that though from the evidence adduced on behalf of the prosecution, it transpired that at the night of the occurrence, on 18 or 19/11/2008, the house of the informant was destroyed by fire. The allegation of the prosecution that the accused person has committed mischief by setting fire to his house is not well established and clear and cogent and reliable evidence. Therefore, the prosecution is miserably failed to prove this case, and therefore they acquitted the accused person, Lordship.
Yes.
Here,
what is the standard of proof in a criminal case?
Lordship, first, the contents of the affair should be...
No. I'm not talking about affair. What is the standard of proof in a... Are you aware of standard of proof? Have you ever read in evidence?
My Lord.
So what is the standard of proof in a criminal matter?
The prosecution has to be...
First principle is presumption of innocence.
My Lord.
So standard of proof is... Are you aware of the term beyond all reasonable doubt?
My Lord.
So then,
here, Lord,
proving to the hilt.
My Lord.
So now how do you say that the prosecution, I mean, how the court will arrive at a conclusion that it has been proved beyond all reasonable doubt to the hilt?
My Lord. Because
please appreciate that.
My Lord.
There can be a strong suspicion. Strong suspicion is another thing. But strong suspicion doesn't amount to proof beyond reasonable doubt.
My humble submission is the occurrence took place at night. And what is the best piece of evidence that by hearing the sound, the PW3 and PW5 came to the spot, and they have specifically named the accused person, that they have saw the fire sticks in their hand.
They have not named. That's a mistake while reading an evidence. They have not named.
PW3, Lordship is...
Please read. As far as the offense is concerned, they have not named anyone. And for that matter, much less PW3 and 5, they have not named anyone for that matter. Running away from the spot. Running away from the spot, is it sufficient evidence to attribute motive and what is called mens rea, actus reus? So the act of running away from a place, can it be extended, extrapolated to say that yes, after lighting the fire, they have run away?
The PW3 says that the fire sticks in the hand of the PW3, Lordship.
Yes.
Because he saw the fire sticks in the hand.
You have not read in the deposition? You have not read in the deposition?
The PW3, Lordship, Rabbi threw away one burning stick and fled away from the spot with the other accused person, Lordship.
I could not read the complete sentence.
My Lord.
Don't read the words. How it starts. Paragraph PW3.
First paragraph, Lordship. I know the informant as well as all the accused person of the case on 18/11/2008 at the night about 1 p.m. in the house of the informant. Incident of this case took place in the night of occurrence while I was asleep. Hearing the sound of the informant, I woke up, and when I rushed the house of the informant, I saw the dwelling house of the informant burning in fire. Also, I saw the accused person fleeing away from the spot. The accused Robbie threw away one burning stick and fled away from the spot with the other accused person. I poured water on the house of the informant to extinguish the fire. Many people of our village also rushed to the spot and poured water, extinguish the house of the informant. The dwelling house of the informant was completely destroyed by fire. Thereafter, that sentence, Lordship, because
cross-examination burning stick कथा कौन पचले cross examination?
Paragraph 5 of the cross-examination, Lordship.
Have you ever seen any kind of commotion and any incident in village or even in cities? People start running.
Here, Lordship.
Running is an activity
My Lord.
which happens after any kind of commotion. If somebody not dousing the fire is an offense defined, then you can they can be held guilty that they were present. They did not douse the fire by doing some overt act. Beyond that, nothing is proved as far as criminality is concerned.
Here, Lordship, for Lordship's kind permission, the cross-examination para 5, Lordship. It is not a fact that I did not state before the court of JMFC Jaleswari in 1CC case number 179 by 2009.
नहीं एटा कौन पचारचंती
Lordship,
से जो देखिले
that the accused Rabindra threw away the burning stick and fled away from the spot, seeing the accused person.
recover ହେଲା कि सेटा
Serious lapse.
there is every possibility that he tried to douse and आपण चाळ घर देखछन केतळे निया लागले कोन करा जाय पानी पका जाय
टाणी
पानी को आसीबो टाणी ओला ताकू कहंती ताळ ओलारिबा पानी नथाए.
That was also not the case of the defense.
Defense case एडा नुआ. Defense has nothing. There is a presumption of innocence. आपण फास्ट कहली सबले मन रखिबे. Don't ever confused that there is a presumption of culpability that defense has to disprove. Simply the defense has to dig out holes in the prosecution case. Here the prosecution doesn't present a case. गारे पानी कोठु आसीबो गारे पानी नथाए
जो हाथ स्टिक अछि जे चालक माने दे वांट टू रेस्क्यू और एक्सटिंग्विश द फायर दैट इज आल्सो नॉट प्ली
they defense free niya jayeni. Please don't do that. Please don't do that. With your experience it is not expected. But I mean never suggest आपण जदि प्रोसेस एग्जामिन करचंती तांको पचारि चंती आपण सी एग्जामिन हेई चंती रबी एग्जामिन हेची रबी रो एग्जामिनेशन देखंत पानीटा सेटा सेतेबेले जो जळे सेटा पाळटा दैट्स ए हाईली फ्लेमेबल ड्राई हस्क ते पानी पानी जेतरे हबनी से पानी इनफैक्ट सेटी नाही गारे अवेलेबल न थाए पोखरी नथले चांस नाही आउ सेतपे गारे जो
आई मे बी पार्डन लॉर्डशिप दैट डिपोजिशन कॉपी अटेंड
नहीं रबी को अनलेस यू आस्क जे तमे जो नै की जाउथलो काठी कोन कलो and he answers that you will find that they would not have asked him because he would have answered that. Once PW3 then what is the contradiction part? पण गोटे सबुदिन उल्टो पाल्टा करी पेज छाड़ी दौरान 12 पेज टा नहीं दियंत आनंद पेज 11 रो कंटिन्यू करंतु सम सॉरी para 11 PW5 who claims to be the eyewitness to the occurrence as stated. Yes पढन सेडा दियंतु जल्दी करंतु आज्ञा मते दियंतु मु पेज बाहर
last line I'm placing during cross examination. During cross examination, step from the date of lodging the FIR till date of filing of the protest petition.
नहीं आपण 12 पेज छाड़ दीजन.
I don't have one page not.
सी छाड़ दीजन. आपण आज ठीक स्कैनिंग.
More than 11 पर डायरेक्ट 13.
सुनंतु मु 12 देखिनी कि आपण देखि नांती बट आई एम आस्किंग यू दैट क्वेश्चन से सेडा कोर्ट क्रॉस एग्जामिन ताको एग्जामिन करचंती से क्रॉस एग्जामिनेशन ने कोन कहिचंती जो देखिले से स्टिक धरि की
They tell about the
313 ରେ ପଚାରିଛନ୍ତି
no.
313 statement ଅଛି
No. It
Accused
play
statement
for
is-
2 days time, Lordship. I can collect the.
Done,
because
yes.
my-
everyone is taking adjournment, why not you are making an effort. Examine କରିବେ 313 ରେ ସେଟା ପଚରା ହେଇଛି କି ନାହିଁ
my lord.
recently there is a Supreme Court decision.
My lord, I'll examine, Lordship.
Fire stick କଥା most likely fire stick has been ତାପରେ ଆପଣ
Cross examination ରେ ତାଙ୍କୁ-
କୌଣସି evidence ଦେଇନାହାନ୍ତି most likely କାହିଁ ତାହେଲେ final form କାହିଁକି ହେଲା in eyewitness account
my lord.
final form of that mistake of fact ଦେଇଥିବେ ଆପଣ ସେ ପେଜ ଟା ଆଣନ୍ତୁ ସେଇ ପେଜ ରେ ହିଁ ସେଟା ଡିଲ୍ ହେଇଛି
My lord.
ଆପଣଙ୍କ ପାଖରେ ତ ପେଜ 11 ନଥିବ ବୋଧେ ସେ ଯା କପି ଦେଇଥିବେ
Page ଅଛି judgment of. Page 12 is there.
12 is there
Page 12 is there.
ଆଚ୍ଛା interesting ଆପଣଙ୍କ ପାଖରେ ପେଜ 12 ଟା ନାହିଁ internal page 12 ନାହିଁ
Nine.
yes Mr. Kanon go
Page 11 starts from the bottom paragraph is page 11.
ha
Again
during
in
cross examination
Page 12 it ends and another paragraph also is typed as paragraph 11. And that ends in-
staff reporting ହେଇନି ନାଇଁ ମୋର ପେଜ ରେ ଦେଖନ୍ତୁ 11
ଆପଣଙ୍କ
ପରେ
ପାଖରେ
13
13
ଅଛି
ନଥାଇ ପାରେ
ନା 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 ସେଣ୍ଟେନ୍ସ ହଉନି ସେଣ୍ଟେନ୍ସ ହଉନି ଆପଣ ପଢୁନାହାନ୍ତି
ଆଚ୍ଛା
ପାରା 11 ଟା ପଢନ୍ତୁ ଇଟ୍ସ ଏଣ୍ଡସ୍
paragraph 11 which starts in page 11
ହଁ PW 5 last word
again
ଦେଖନ୍ତୁ
PW5 who claims is the first
during
last is during cross examination
ତାପରେ
he has stated that there was a fence
ତାଙ୍କର ଅଛି there was a
there was a he has stated that there was a fence in between the house of the accused person and the informant. He admits that he did not chase the accused person at the spot. Full stop. Paragraph ends there.
ତାପରେ
Instead of paragraph 12, it is again mentioned as paragraph 11. From the above noted evidence adduced on behalf of the prosecution and the documents exhibited on its behalf, it further reveals that informant has made allegation in his complaint petition exhibit 2. So this is a case where serious discrepancy is there between exhibit 1, the FIR which was lost, and exhibit 2 where the complaint case was subsequently lost after 8 months.
not only that after knowing the investigation they have lost the complaint
Yes, after the
have
investigation by
improved
the
it.
prosecution was closed, complaint petition was lost. So this is a case where smell of grudge,
not only that afterthought it's a clear case of
pure
improvement.
afterthought. Exhibit 1 should have been, it should have been mentioned in exhibit 1. Some hint should have been given that somebody said fire.
ଆପଣ suppose 2 affairs are lost
My lord.
in 8 months gap
My
you
lord.
have heard the Leonard AG then what would be the consequence the second has to be rejected
My lord.
first one is to be rejected because you see the delay in lodging FIR and 2 affairs there is clear cut decision
First affair should be considered.
first FIR and here there are 8 months they write in a it's not an FIR it is write in a complaint
It's
case
a complaint case.
then that is how such gross discrepancy is there
Absolute improvisation of case to
हाँ.
victimize some innocent person. Baleswar area रे इटा rampant हुए. तो आपण आणतो
recovery କଣ ହେଲା ସେଟା ବି ଦେଖିବା କଥା ତାଙ୍କ ଘର କେତେ ପୋଡିଥିଲା ଯଦି ସେମାନେ ଶୋଇ ଯାଇଥିଲେ ରାତିରେ ତାହେଲେ ତ there is very less chance of recovery also ତାପରେ adjacent houses
My lord.
is rarely burned because once the fire is set up it will burn the continuously because all the houses
ସେଇଥି ପାଇଁ ଚାଳ ଓଲାରି
हाँ.
just to discontinue the
discontinue the fire ଆଉ ଆସି କହୁଛନ୍ତି ତାଙ୍କର ଲାଗିକି ଘର ଅଛି
PW3.
ଇନଫର୍ମାଣ୍ଟ ଆଉ ଆକ୍ୟୁଜ ଭିତରେ ଘରଟା ଲାଗିକି ଅଛି ନା କୋଉଟା ଆପଣ ପଢୁଥିଲେ ଯୋଉଟା ନା ଇନଫର୍ମାଣ୍ଟ ଆଉ
there was a fence
Fence.
rather
ନା, ନା.
ଲାଗିକି ନାହିଁ.
ଫେନ୍ସ ତ ଅଛି ବଟ୍ ଡିଷ୍ଟାନ୍ସ ଅଛି ଯୋଉ ଫ୍ଲେମ ରେ ସେଟା that
It
catches
could have
fire
caught fire.
ବାଲେଶ୍ୱର ଘର are not like south ଯୋଉଟା କି ଲାଗି ଲାଗିକିରି but still then ଦେଖନ୍ତୁ ଆପଣ ମିସ୍ ପ୍ରଜ୍ଞା ମହାନ୍ତି ଫର ଦ ପିଟିସନର ମିଷ୍ଟର ଷ୍ଟେଟ କୁ ପାର୍ଟି କରିନାହାନ୍ତି
ଅଛି state ଗୋଟେ perform opposite party ଅଛି.
Mr. AGA, SS Kanungo AGA for the state, the learning council for the petitioner placed the judgment impugned in the present revision, particularly evidences of PWs 3 and 5.
Hello.
C6 further accommodation. to advance arguments. When do you want?
Week time, Lordship. Is Friday, next Friday, May 8th.
First.
My lord.
1st of December 2023. No instruction, Mr. Mishra.
Yes, madam. Short time.
Mr. Tukuna Kumar Mishra for the petitioner, Mr. S.S. Kanongo, AGA for the state, the Lord Counsel for the petitioner seeks accommodation to obtain up-to-date instructions, further accommodation to obtain up-to-date instructions and advance arguments. As paid for January.
Yes, my lord.
List on 5th. नहीं सबू आपण काली बहुत 4-5 रखछन हम कैलेंडर दियाला से थिपे 11 11/1/2024.
Oh, bless one.
Item 3.
Lordship, pray for adjournment. Mr. P.K. Malik for B.K. Das के अछंती हेबे P.K. Malik on behalf of B.K. Das for the petitioner. आपण जोतरे सबले अपियर करछनी फाइल स्टार्ट फाइलिंग दैट मेमो सब बेले प्रॉक्सी काउंसिल काई होउछंती आपण इट्स नाउ इट्स योर रेगुलर ब्रीफ. Mr. S.S. Karango, AGA for the state, Lord and Counsel for the petitioners seeks accommodation to obtain up-to-date instructions from the petitioner as prayed for list 12 January 2024. Next.
4.
So Mohendra Kumar Mahapatra for the petitioner. Mr. S.S. Karango.
Conviction, Your Lordship.
Yes.
Your Lordship, on 9/7/2013,
Yes.
the miscase number 808 of 13 has already been disposed of, Your Lordship. But wrong noting has come that it is pending.
Realization of fine has been stayed. There was direction for any imprisonment. The only fine was imposed.
No, fine as well as
Imprisonment was also the
Imprisonment.
sentence was there.
So that miscase is for imprisonment. What is the 2 months RI? आपण कोथरे स्टे करले मागिले बेलटा मागिले बेलटा कोन हला
808.
808 बेलटा
Bail allow ହେଇଛି.
केबे को पिटिशन
9/7/2013, Your Lordship.
Miscase 807 बोधे ना कौन?
808
808.
अच्छा
97 मु कहीं पाउनी
May I permitted to send the certified copy, Xerox copy of the
से
certificate?
देखिबे जेरोस कॉपी कोन कोर्ट रे इंक्लूड करी हबो
No,
It has to show it.
certificate copy टा जो
the original record has to have to stand testimony. देले ब्रीफ टा दियन सर्टिफाइड कॉपी दियन पेज ही नहीं आगे दुई तीन ऑर्डर काढन तब ऑर्डर चारि एक पर चारि केमती हला रजिस्ट्री को दियन तो एक्सप्लेन करिवे कहीं 2-3 पेज कहीं 2-3 So Mahapatra, thank you. It's our issue. Mr. M.K. Mahapatra for the petitioner. Mr. S.S. Karungo, AGA for the state. The matter has been listed for fresh admission along with miscase 808 of 2013 indicated in the cause list for bail. The learned counsel for the petitioner submits that miscase 808 of 2013 was considered earlier by this court and by order dated order number 3 dated 9/7/2013 The miscase was disposed of. Bail was granted. The order sheets of the case brief maintained in the registry of this court does not contain the order number 2 and 3. After order number 1, that is 3/7/13, when the matter was presented in the court, the next page is blank, is scored through, and the next page indicates order number 4 dated 22/7/2013. The matter to be placed before the registrar judicial to make an inquiry, and steps be taken for the reconstruction of the brief. The learned counsel for the petitioner produces photocopy of the certified copy issued on 11/7/2013, containing the order number 2 dated 9/7/13 and order number 3 dated 9/7/13. ये कॉपी अपन पारे अछि करी गाना याद करी गाना. The said copy is kept on record, which shall be also be placed for before the registrar judicial. बड़े गले से एटा एथरे गोटे कोन अछि एथरे देखछन अपन ए शेषरे गोटे कोन अछि देखिता. This case 808. तापर गोटे लाइन लिखंतु at the last pages of the case brief, photocopies of the order number 3 and order number are available. However, the order number 2 is not available. Also, ଆପଣଙ୍କର order sheet ବି ସେ ଦେଖୁଛି.
ମୋ ଅର୍ଡର ସିଟ୍ ଦେଖୁଛି ଆଜ୍ଞା 808 ରେ ବେଲ୍ ହେଇଛି.
The learned AGA also submits that, referring to his brief, submits that his brief also indicates that on 9/7/2013 na kete order କହିଲେ 9 by 22/7 now 9/7 like
807
in miscase 808 of 2013, bail was granted. The registry shall put up a note before the registrar judicial regarding such discrepancy in and non-availability of the copy of the order sheet. The copy no, non-availability of the order sheet itself. Order sheet. Yes, next. Mr. Mahapatra, you wanted to say something?
Yes, Lord. That's because bail and fine has already been stayed. So let us come on the hearing distance.
Period already undergone kichi achi?
Na period undergone.
ନାଇଁ ସେ ଯାଇନି.
Immediately ହେଇଥିଲା.
Immediately was.
Because there was no delay filing this review.
Now there's benefit of probation of offenders that can be granted.
Your lordship.
No, what is your submission on that?
Yes.
ଆପଣ ମାନେ କହିବେ ନା କେହି କିଛି କହିବେନି ଯଦି କେମିତି ଚାଲିବ ତାହେଲେ ଠିକ ଅଛି. The matter be listed on କେବେ ଚାହୁଁଛନ୍ତି? ଜାନୁଆରୀ
Any day next week, your lordship.
ଡିସେମ୍ବରରେ ରଖନ୍ତୁ. 19 December.
Yes, your lordship.
ସେ କପିଟା ଆପଣ ନେଇଯିବେ.
Yes.
ଗୋଟେ ମେମୋଟେ ଲେଖି ଦିଅନ୍ତୁ. ପେପରଟେ ଦିଅନ୍ତୁ, ସେ ମେମୋ ଲେଖିଦେବେ. Photocopy of so and so is filed in court today.
LCR also not available as per the notice.
देखिए अपन पर डिपोजिशन अछि की?
Yes, your lordship. Some of them. I'm having all the.
ସେଟା ସେଇ पेजଟା ନାହିଁ, ଆଡମିशन ହେଇଛି କି ନାହିଁ ସେଟା ଜଣା ପଡୁନି.
Because
ଆପଣଙ୍କ ଏରେ ଲେଖା ହେଇଛି ନା ଆଡମିସନ ବୋଲି ଆପଣ ପଠେଇ ଦେଲେ ତ ଜେରକ୍ସ କରିବା ପାଇଁ
no, ସେ LCR ବି call for ହେଇଛି
ହେଇଛି ତାହେଲେ
ଆଜ୍ଞା
ଆଚ୍ଛା
order number
LCR as called for
order
ଦେଖି
number
ଲେଖିଦେବେ LCR as called for by order dated so and so shall be obtained scanned copy be obtained updated
order,
yes.
order number 2 ରେ admit କି LCR call for ହେଇଛି order number 3 ରେ bail was granted.
yes ସେଟା ମୁଁ ପଠେଇ ଦେଇଛି ତ so I
ଆଜ୍ଞା।
am unable to refer to that yes
item 5,
Item 5 and 6, my lord.
yes
Case where I will get instruction in a day or two. Other
the
co-accused,
chart is there
that he will provide. That I,
no chart is there in the all the cases
It is there, but this one is recent. The rejection order is of 6/1, so we haven't got any details to call for the records.
rejection order of 6/11
11.
11.
oh.
They are subsequently arrested. They are subsequently arrested. my lord.
all subsequently arrested are named by the co-accused
Yes.
Yes, they're named by the court, my lords.
Their role has to be ascertained.
that what you have
But their role is more complicated in terms of IO. So I will satisfy
that chart is just get that chart also.
The chat, I'll call for all those documents again. and
That
see.
chart is there in your connected matter. It will be there because what you have provided, the photocopies are retained in all the briefs. So in your brief, that calendar of evidence.
But it is every file is, isn't it?
Last week, call it next week. We'll
Well,
get the.
Yes,
Similar 40 persons have been released.
I understand.
That-
I understand. But I remember even. So that is how I am asking regarding that calendar of evidence and in that table, these bail applications are not there. These are fresh bail application that they are saying.
this is a fresh bail application, and their
26/7.
complicity is slightly complicated than the other co-accused. That
Could be, but
a week time be given, my lord, or two,
next
three-
week as well.
Again.
Because already all the materials
Yes,
are on
yes,
record.
yes. Materials are there.
will be getting that.
For- your name, madam?
Mr. Amitabh Das filed VNAMA yesterday, my lord.
Yes, what's your name?
On behalf- Yes, Das.
S. Das. M.S.S. Das. As instructs for the petitioner, Mr. S.S. Kanungo, AGA for the state.
In item 5 and in item 6,
Six.
Mr. Naik is there.
Item 6, Devasis Naik. The learned counsel for the petitioner submits that she has entered appearance after consent was given by the learned counsel who was appearing earlier on behalf of the petitioner. The learned name of the learned counsel, M.S.S. Misra.
A Das.
S. Das.
A Das.
Actually, you are just not speaking to the microphone. Just adjust it.
A
It's
Das.
A.
on-
Das be indicated in the cause list. Name of the earlier learned counsel, Mr. Siddhartha Misra and associates, be deleted. The learned AGA seeks accommodation to obtain instructions, but it is not dispute. It is agreed at the bar that the similar matters have been disposed of. Similar batch of petitions have been disposed of on by order dated
15/11/20.
15/11/2023. The next list on aji kete hela 23 24 list on 29th 29/11 then 6
item 6,
same order Devasis Naik AG
7,
Item 7 on behalf of Mr. Prasad, I may be pleased, Your Lordship.
yes
Virtual mode, my lord.
yes so, you obtained instruction.
My lord, yes, I was talking with.
File an affidavit on the amount
Why?
deposited.
Yes, you filed that affidavit.
And that affidavit has already been filed since, that is on record also, on 7/11/2023, my lord.
Right.
7/11.
2011 order ta. Matlab 2011 order.
2011 order is there. So why the
2011 order, Your Lordship, I took adjournment to obtain instruction with regard to that proposition, whether.
in which affidavit you are referring to that amount you are going to deposit?
No, that
No
affidavit,
affidavit.
that affidavit is not filed. For that purpose, the matter was posted today.
Right,
And
right.
I took,
That I'm
yes,
asking. That I'm
took-
asking actually.
I took instruction from the wife of the petitioner. My lord, at present, they are not in a position, my lord, to make any deposit. Only they can, it can be effected in the event the petitioner is comes out, because during, before the,
Total amount kete? What is the amount allegation of total amount they have?
21 lakh.
21 lakh.
21 lakhs. This is the total amount. It's
Total.
the only case or in the chart re kete total kete ach?
Total,
total
case ଅଛି.
Sorry?
ଚାରିଟା କେସ୍ ଅଛି।
So charta case re kete hela?
ଚାରିଟା କେସ୍ ରେ ହଉଛି ଗୋଟେ 5, 2, 7, 8 ଲକ୍ଷ 21, 29 ଲକ୍ଷ 20 ହଜାର। ତା ଦେହରୁ ଗୋଟେ ହଉଛି
So after defrauding people of 35 lakhs, they have become paupers. So they are the I mean, they are guiding their fate.
18 ଲକ୍ଷ ଟଙ୍କାର ଚେକ୍ ବାଉନ୍ସ କେସ୍ ପେଣ୍ଡିଂ ଅଛି।
Apart from this,
That
they are guiding their fate, sir. Let them.
What happened?
So I mean, it's their choice.
No, my lord, I also, I had a complete comprehensive discussion with the wife of the petitioner with regard to.
So people who after swindling money go pauper. They are guiding their fate, Mr. Mahapatra.
So that is,
After 40 lakhs, they have swindled away for no reason. Just imagine the victim. You should have a comprehensive discussions with the victims. Then you will have a proper perspective of the case you are presenting.
and here the.
I mean, you see, this jurisprudence has got complicated like this. You target people, extract money, keep that, then you go pauper. As if it is a volatile, something very volatile, which like something very volatile, on overnight it vanishes. And then you come to the court seeking sympathy that I have become a pauper.
Not exactly that.
And you just imagine a poor person committing a petty crime, he is unable to furnish his bail bond. He's inside custody.
Yes.
So comprehensive discussions you should have with the persons who have been duped. What is the modus operandi? To sell property.
shell property, false document ଦେଖେଇକି
Yes.
In fact,
And Mr. Mahapatra, this industry doesn't require any investment. Photocopy costs 1 rupee. So few bunch of paper, you dupe people, then go pauper, go bust.
here is already inside custody for more than 8 months.
Sir, where he can be, he's a pauper, he's being taken care by the state. If he's not attended to, there is a prison jurisprudence developed by the Supreme Court, by High Court. If he's not getting food or anything medical, we are day in, day out, we are directing. We are not asking what is the offense who has committed. I'm sure you are not addressing that he's not taken care in the inside custody.
No, sir.
So obviously, a pauper is better inside custody, sir. Who has swindled money about 40 lakhs. And he has nothing to do, no money. So better he is treated as a state guest, given hospitality or whatever, not hospitality. I mean, jail is not a place where it can be said that it is hospitable, but at least basic needs are satisfied.
So far, the other cases which involve, apart from 21 lakh, other cases he is on bail. In other cases, because of
Could be. And has he deposited anything there?
No.
So let him be.
And here the offense alleged.
Somewhere, Mr. Mahapatra, these things always not pass on. Somewhere somebody gets stuck.
That is
The luck, or you say the law catches up.
yes. But here the offense is under section 420 IPC, my lord. Here till that.
Sir, which offense is not for the persons who are in custody are sent to jail and all that by Supreme Court even? Do you think that they are accused of 302?
No.
So then what is this argument? What is this argument that 420? The problem is that you are targeting people. You have a modus operandi.
No.
It's not that you accepted 100 rupees or 500 rupees, did not return. You plan it how to work out with some 5-10 people, take money from them. Then things get busted. And what happened to the money, nobody knows. It is a matter of investigation again by the state. And
Yes,
this
my lord.
deposit, Mr. Mahapatra, this deposit is not to be taken by in any event the victim who has been duped.
But here, my lord, even though he's in custody since
Mr. Mahapatra, even Mr. Mahapatra, even after incarceration during trial, people are getting acquitted in these kind of matters. So that is nothing unusual.
here say 10th from 10th March 2023 is in custody, my lord.
The informant is there. Informant is there.
Yes.
You ask him how he will support you. He has come to court telling the court that I have been duped with my money. This fellow has taken away. I am not conducting a trial. I am considering a fourth attendant petition for grant of bail.
Yes, yes. Here he is already in custody 8 months. The trial has not been commenced. Offense maximum.
Trial commence. Trial submission. Trial commence. 4-5 witness already examined.
Trial commence.
Not only they have duped their clients. They have started duping you also. As far as the instructions are concerned, or maybe Mr. Pasayat, who is the instructing counsel.
No, I was taking instruction with regard to that proposition of making certain deposit. But
They will not. They will not.
Yes.
They will not. They know how to utilize the system. They know how to utilize the system.
this is the position I must.
These are series of cases. After first case he has done it, or after committing the crime he was. He's behind bar for the first time.
Behind bar first time.
No.
That is perhaps only. Yes, Mr. Mahapatra is differing. So every time he was granted bail, he duped more people.
No, in PS case number 345 of 2022, Hon'Ble PS case, he was arrested and all these cases were by that implicated.
So that he's saying.
But this is the case.
We're seeing a serial offender that he starts his career from 2016, 17, even for last 10 years they're active. So that I was trying to understand what is the behavior. Since how many years he's into this? Either you get a rejection order or you adjourn. It's your choice. And you see, they're trying to negotiate. That's the problem. I can't look the other way when the informant comes and says that he has not been, and he has gone. You see, the real pauper is who arranged that money to give him with the hope that he will get a plot.
Here, by allowing also him to be detained, also the informant will now be benefited.
Exactly, that I told you.
Yes.
He's not getting money, but at least this fellow has not duped any further. Because the more he dupes, he becomes more a poorer person. So at least now he is level, not getting still poorer.
Actually, some paisa guda kaane ki chit fund lagay deji aur nije bhi naam.
So whatever say what. Like कितने number item?
7 item.
7. Mr. Dipti Ranjan Mahapatra on behalf of Biswajit Pasayat for the petitioner. Mr. Devasis Naik AGA for the state. Mr. Brundavan Raut for the informant. The learned counsel for the petitioner seeks further accommodation to obtain instructions. In view of the deliberations as noted in the order dated 2/11/2023 and also the deliberations today in the court. When do you want, Mr. Mahapatra?
Today, after 1 week.
December recording. 14/12/2023. Yes, next.
Item 8.
Item 8, Lordship, last occasion direct.
Satyajit Mahapatra for the petitioner, Mr. Devashish Naik, AGA for the state. So you took time to file another affidavit, supplement.
The details of the case status along with
That has been filed.
Just now I received an affidavit from the lower court counsel.
Okay.
I will file.
Mr. Satyajit Mahapatra for the petitioner, Mr. Devashish Naik, AGA for the state, Mr. Subhankar Raut for the informant. The learned counsel for the petitioner seeks further accommodation to file affidavit in terms of his submissions recorded by order dated 13/11/2023. Yes. When do you want, Mr. Mahapatra?
8th.
8th dele apna kebe debe aaj to
Just now I received. I will. This week I
instruction
will.
now padibo tanku. Apna obasyo ebe match karibo hopefully. So you file it early. Apna 8th aji to December 8th ko chanti. You are filing it today by Tuesday. You can file it 28th. The affidavit will be filed by 30th.
Yes.
List on 8th of December. 34 days. 8th of December. Yes. Copy of the affidavit be served on the learned AGA so as to enable him to obtain instruction. Yes, please. Sub item कौन है, Mr. Mahapatra?
Same affidavit has to be filed.
Same order. So Mahapatra, sub item, there is another petitioner, same order, same date, so identical order. Yes. 9, Mr. Naik, Vipin Naik.
At 9, I was supposed to obtain threat perception.
Yes.
I have not received those instructions. My lord, may kindly keep
Mr. M.S.Sahoo for the petitioner. How much time, Mr. Naik? Mr. Devashish Naik? How much time?
My lord, it's a week.
The learned counsel for the petitioner, Mr. AGA, the learned AGA seeks further accommodation to obtain instruction in terms of the earlier order dated 15/11/2023. Today is 24th. List on 1/12 or 4/12.
4/12.
On 4th of December 2023. Yes.
Item 10.
M.S.Sahoo lekhi. Yes, petitioner. Yes, next.
May it please your lordship.
Yes.
My lord, your lordship kindly see order dated 15/11/2023.
Yes.
Your lordship directed to my learned senior to take instruction regarding the order dated 1/11/2000. Later in afterthought, my learned senior submitted before your lordship.
I have submitted a written report before the police. Your lordship directed the state council to take instruction to that effect.
That is
When he is jail in custody, my lord, he is sending
That
another
is your
person.
allegation. That is your
Yes.
allegation. Have you received, Mr. Mahapatra? Just a second. Just switch on your microphone. I think it is switched off.
Sorry, my lord.
You are Golekha Sahu.
Yes,
You
sir.
are for Golekha Sahu. The
Yes,
informant.
The affair, my lord,
This
subsequently
this particular
registered.
PS cases, where this BLAPL 9834, the
That
PS
is
cases.
393 of 2023.
393 of 2020.
But subsequently, FIR, my lord, I have submitted the subsequent FIR, my lord, on threat by the henchman of the petitioner on the informant. That has been, my lord, registered and that has been investigated. FIR false, my lord, report has been submitted.
Acha, acha.
And also with regard to the health condition, lordship had desired to know.
Yes, yes.
That has been mentioned. That he is okay.
Health condition ta kouthi achi ki?
That is on the report, my lord. On the first page of the report, lordship.
This one.
Yes, ma'am. And also in the next page.
Yes, Mr. Sahu, it has been Investigated by the
Without
police.
calling the informant, my lord, the police has submitted the report.
Could be.
I have to take instruction.
Could be.
That beg pardon, my lord.
Could be the police has not properly investigated. So 439 I will issue a
No.
please.
I have just
So,
submitting, my lord.
since last 2 months, though you have now less frequently appearing, I have been very
Yeah.
particular in my deliberation that be specific and pertinent to the case at hand.
Yes, my lord. I am submitting, my lord.
I think police not doing anything. That's another.
No, yes.
They-
I am submitting, my lord. The petitioner is a patient, my lord. He is suffering and open heart surgery was conducted. Thereafter,
Sir, I remember. I have a problem of remembering things.
yes, my lord. That
So,
thereafter he is,
Mr. Sahoo, so please that because perhaps you did not hear him, because I asked for that only. What is his health condition? So that is how he was responding to that.
no,
The petitioner is not the informant.
but he is on
You are arguing for the informant, not the petitioner.
I am arguing for the informant, my
Yes,
lord.
he
He
said
was on.
He was saying the petitioner is a heart patient. No, the informant is a heart patient.
Informant, my lord.
So you said petitioner.
I'm sorry, my lord.
So why you should be sorry?
I am for the informant, my lord. He is a heart patient. Open heart surgery was conducted, my lord. Thereafter,
Is
he.
there any difficulty in medical aid being provided to the informant? Then you inform the court. You can file a writ also. No problem.
No, now he is suffering, my lord. No. I am submitting, my lord. Now he is suffering, my lord. He is unable to move, my lord.
The Learned had yes. Please kindly complete your submission. Because again, I'll start dictating. It will be interrupted. Please,
No. I am submitting, my lord.
please carry on.
No, the
Yes.
son of the informant, my lord, now suffering, my lord, he is unable to move.
Son of informant or the informant is a heart
No,
patient?
Son of the informant. He is
Informant,
the injured.
Who is the injured?
informant is the father, son is the
Injured
injured.
person?
Injured.
Regarding health condition, you have
Injured.
Yes.
Injured.
Yes.
Now he is unable to move, my lord. He is completely bedridden in the house. That is my statement. Your lordship record that.
You are not taking care of him.
I am taking care, my lord.
Hospitalization?
Daily routine, my lord. I am taking to the hospital and he is completely bedridden.
For what, sir? Who caused the heart problem?
He is a heart patient, my lord.
Medical
Thereafter, my lord.
You give the medical report.
My lord, I'll get, my lord.
No, medical report regarding the condition of the victim. Examine नहीं थे वो.
My lord, prior to that,
CD टा दियो ना.
he was treated in AIMS.
He might be having 1,000 diseases. But what was his condition after the injury? That I wanted to say. That I want to see.
My lord, while
You see
investigation
the
was,
date of open heart surgery केबे ହେଇଥିଲା? ଆପଣଙ୍କର
Before occurrence, my lord.
Before occurrence.
Before occurrence.
So ଦେଖନ୍ତୁ occurrence ରେ କଣ ତାଙ୍କର injury ଟା
occurrence ରେ, my lord, he was admitted to AIMS.
ସେଇଟା ମତେ ଦିଅନ୍ତୁ ସେଇ ପାର୍ଟଟା flag
My
କରି
lord,
ଦିଅନ୍ତୁ. Yes, Mr. Sahoo. Yes.
When he is doing his livelihood, all on a sudden the petitioner came with a knife, my lord, stabbed him. Thereafter, he is shifted to medical. He suffered for some days and discharged. Now he is completely bedridden in his house.
But this morning, my lord, the IIC, he has already talked with the informant and also given the report, my lord. He confirmed his son is okay and he is doing his personal bars.
Another mobile.
He had sustained stab injuries by the petitioner, my lord. The knife was recovered, leading to discovery and all.
Dilip Sahoo is injured. Who is the injured? Dilip Sahoo.
Dilip Sahoo.
Yes, sir.
Dilip Sahoo. Yes.
Dilip Sahoo.
Is he related to you? We are getting so emotional. So
No.
okay.
Oh God.
Extramarital relationship.
Extramarital. My lord, alleging extramarital relation.
Oh, his statement was also recorded. After he was injured.
My lord,
his
audio.
statement- I'm sorry. After he was injured, his statement has been recorded also.
Yes, my lord. His statement has been recorded. That is.
While under treatment. The Mr. Kabiraj Pradhan for the petitioner, Mr. S.S. Mahapatra, Additional Standing Counsel for the state, Mr. M.S.Sahoo for the informant. The submission of the learned counsel for the informant as recorded in order dated 15/11/2023 that a certain subsequent incident alleged to have been committed by the petitioner while petitioner as per the instructions of the petitioner while he is in jail custody. FIR was lost. The learned and on 15/11/2023 the following order was passed. Order ta quote kar debe. The learned ASC has received instructions from the IAC Tangi PS Khordha. You have the extra copy of this.
No, my lord.
Okay.
I'll call
Copy
it.
of the instruction containing the FIR as well as the written report of the Golekha Sahu informant.
My lord.
Yes.
Golekha Sahu informant. The instructions received from the police as produced is discloses the following as per the written report of Golekha Sahu up to dated 31/10/2023. Regarding the health condition of the injured victim, it is also indicated in the said report that the injured has been discharged after treatment from the hospital. He stays at his house. It is
That
also
was-
seen from the case diary. ତାଙ୍କର ଲେଖନ୍ତୁ ସେ ଯାହା କହିଲେ
ନାଇଁ
ଲେଖିଲା ପରେ
ନାଇଁ 110 ରେ ଆମେ ଦେଇଥିଲୁ ସେଟା ଆପଣ କହିଲେ 3110. I have submitted on 110.
କୋଉଠି କହିଲେ ତାଙ୍କୁ ପଢିକି ଶୁଣାନ୍ତୁ 3110 ବୋଲି ଟିକେ ବଡ ପାଟର୍ନ କଲେ ଆପଣ ଯାହା କହୁଛନ୍ତି ସେ ଶୁଣି ପାରୁନାହାନ୍ତି slowly କରନ୍ତୁ. Instructions received from police as produced discloses the following. Then quote the paragraph. As per, it starts with as per, then ends on 31/10/23. ମୁଁ କୋଉଠି ଡାକିଲି FIR dated 31/10/23. Disoriented ହେଇକି over confident ହେଲେ ଏ problem ହୁଏ. You are disoriented. You are not listening.
3110.
And you are also presuming that the judge doesn't listen. The judge doesn't.
No. I have not.
Then what is this fun? You see, now you can see the entire replay. Eta live achi ta. The play kar de tanga pai. Let him see that what he is doing. See how serious and tragic it is. You are not listening. Don't realize what is dictated. I quoted a paragraph from that report that starts with as per the written report. Everything is there. That is how one has to save time. If I start reading the entire thing, because it will be anyhow written and ends at by FF number 676 dated 31/10/23.
Yes.
And I have to explain you that because you feel that I have dictated something wrong.
No.
Then why you interrupted? You say that you did not want to interrupt me because you feel you said also that the FIR is dated 110. Lordship has dictated. You see, you can see here. Because now the no also is recorded here. We very categorically said the FIR is 110, the Lordship dictated 31/10.
ମୁଁ କହିଲେ କାଳେ ଭୁଲ ହେଇଯିବ ବୋଲି କହିଲି ଆଜ୍ଞା.
Oh, you are so caring about me. Thank you. Anyway, my orders are all appellable.
I-
So I thought that, yes, the treatment from the hospital, stayed at the house. Please notice that on 12/5/2023, while the informant, the injured victim was under treatment, his statement was recorded in the All India Institute of Medical Sciences at Bhubaneswar. The learned counsel for the petitioner submits that the petitioner is in custody since
13th May 2023.
13/5/2023.
Charge sheet already submitted.
The final prosecution report has been submitted
On 4th August 2023.
4 August 2023. The learned counsel also refers to the affidavit filed on behalf of the petitioner through his father, that the petitioner has no criminal antecedents. You informant criminal antecedent अछि ki ta puora?
No.
There's no criminal antecedents. The learned, it is submitted that the petitioner, being a local person, shall subject himself to the jurisdiction of the learned court in session of the matter, and also shall abide by terms and conditions that would be imposed by the learned court in session of the matter. The learned additional standing counsel, referring to the materials contained in the case diary, opposes the prayer for bail. The learned counsel for the informant, with utmost vehemence, opposes the prayer for bail, stating that the injured victim is bedridden in his house. The injured victim had a heart operation, open heart surgery. Kebe hitile? Open heart surgery on so and so date. In the year?
2023.
In the year 2023, date ta dekhile kebe?
Date. 13 May 2023.
13/5/2023.
13 May 23.
And he's being nursed by his father informant at his home. The learned counsel for the informant submits that since the father of the informant father is nursing his son, the petitioner should be refused bail. The learned counsel again highlights the FIR before the police dated 1/10/2023, which was filed during pendency of this petition.
My lord.
Which was filed after the present petition was filed on. The kebe file kale Mr. Kabiraj.
Sorry, my lord. On
Aji to siya apanko form re achanti. Apan jo speech diyanti.
28th August 2023, my lord. I have filed this.
Apan Nachuni college na ko portile par kon thile union leader na kon?
My lord. Then
Nirakarpur college. Kon likhle? The FIR was filed on?
FIR was filed.
Instead of dekhi lekho.
12/5/2023.
देखियो डेट पेट देखियो की. Why you are so jittery?
No, yes.
आपण टे दूरे छिडा होनांती सी आपण को फॉर्म रे अछंती अछि.
He's my big brother.
Big brother जे फॉर्म ता आपण उठ नै जैचंती से. FIR was filed on 1/10/2023. Petition was filed on 28/8/2023, challenging the rejection order of bail by the learned additional session judge Khurda on 16/8/2023. As per the instructions provided by the investigating agency, that out of the said FIR dated 1/10/2023, FF final form has been submitted by FF number 676 dated 31/10/2023. FR is FR full form called Mr. Mahapatra. What is full form of FR?
My lord,
False.
FIR false.
FIR
False. My lord, when it is without having any.
I mean mistake of fact or mistake.
No, mistake of fact is different, my lord.
It's FIR false.
FIR false. Here, my lord, no evidence comes from the informant side to support.
No, that
this.
is how I noted. That is
For
how
that-
I noted. On 28/8, this case was filed. The FIR is lodged on 1/10.
It has been returned to him, to the informant, as per FIR false. My lord, it has been returned to the informant. It is without any supportive evidence, because he has not given any 161 statement or something, my lord, to.
Acha. To that, he did not cooperate with the.
No, didn't cooperate. Yes.
Instruction dated 24/1/11/2023. 2020. Having heard the learned counsel for the petitioner, the learned ASC for the state, and the learned counsel for the informant, the court is inclined to grant bail to the petitioner subject to such terms and conditions that would be imposed by the learned court in season of the matter. We shall also include a condition that any violation of deviation from any of the terms and conditions shall lead to filing a petition for cancellation of bail by the investigating agency. That copy kari upon debe na mu kari.
Lordship may keep it. I have other copies.
You have a
I
copy?
can draw it. Yes, man.
Just go. ठीक है. That's upon rakhi document. Yes.
Obliged.
11th.
Yes.
May I please, your lordship?
Yes, please.
This case where the petitioner is in custody, my lord, since 28th August 2023. And the allegation,
the other matter, anything happened in all those cases?
that is anticipatory bail dealt by another judge, but the Supreme Court decision says,
Anticipatory, Pradhani Jani, anticipatory bail is not a problem.
yes,
But regular bail 439 is not pending before any other.
it was listed before Honorable Justice Savitri Ratha, my lord.
So she said because that is how it has come before me, because it's not my assignment. That's a noting by the Honorable the Chief Justice, Acting Chief Justice. Yes.
Last time, your lordship also, this is a case, my lord, where the petitioner, who was a government servant, and the accused, and the informant is a government servant, my lord. He was serving in the government department. The accused is his own nephew, sister's son, and it is alleged that during his service period, he has given 20 lakhs to me, no document, nothing, giving 20 lakhs to me to keep. Thereafter,
The government servant has given 20 lakhs to the nephew.
yes,
You are for the informant.
My lord.
your lordship last time only wanted to know.
They are relatives.
This particular person is not my nephew.
No.
Other two accused persons, my lord. One is my brother and another is my nephew. They
Say bhai ra banaja, say bhai ra banaja, other accused banaja.
No, it is interstate dispute.
Yes.
Na professional like they have been
professional
cheating.
My lord, kindly see the charge sheet has already been filed. Kindly see the charge sheet.
Sir, he's a serial offender or this is the only instance?
That's all.
So far as the investment is purpose for the mutual fund and to deposit before the postal and all. That is there. My lord, may I read those things?
No, sir. I'm sorry. I just forgot your name.
Vishwanath Patnaik, my lord.
Mr. Patnaik.
My lord.
You are just saying what he's saying. He's saying it is a interstate dispute. You are also saying that he took money from for investing in mutual fund.
In mutual.
How he got the money? I am not asking that. Both of you are saying the same thing.
Yes.
Is it that this person, whoever has taken away the money, he's into that kind of a activity? His modus operandi is that, or this is the incident between you and the your, I mean, three
No, no, no.
persons.
His job is to collect the money and deposit somewhere for.
How many allegations are there? Then you straight away say that. So when the specific question is asked.
No allegation, no allegations. I am his relations. Tonka vigilance case tanga nar thila. Tonka mati ki deiti rokhe pai. Mu tanga putra ko kaku dei deiji. Putra bhai ki dei deiji. Putra bhai tanku dele nahi. This is a interception.
Vigilance case is a fact.
Yes, you must admit.
No.
Facts
No,
are-
not that way. I have not. You see,
It's a fact. It is a fact.
So I am a government servant, my lord. There is a vigilance case, but this is a criminal case.
but anyway, Mr. Patnaik, what he's saying, you are saying the same thing. That he's not a. I mean, he's not. I mean, Mike Perry has he indulged in similar activity as far as any other person is concerned, as per your knowledge even?
No.
Because this question actually you should not answer because you are only a informant.
Yes.
No,
Here, Mr. Mahapatra will, the senior count, they will answer.
Yes.
Then what is the ground of rejection?
Rejection for first or second or
Page 5. Page 5 पर जाए.
Sessions court reject करने 406 रे थिला.
Since what is the age of this person?
Young,
31 young boy, 31 years.
And the amount of so Mr. Naik, you have instruction now to what amount he can deposit.
Deposit again.
In the earlier orders also, my lord.
Just
Mr. Patnaik, not in these kind of cases. Not in these kind of cases. There is no order. But still I am asking him if he has any instruction.
टोंका फेरे दीजिए जहाँ कोई भी जहाँ कोई.
No. Those conditions will be there, but that I am not imposing a condition. You must have marked. That I am asking to show your when you are seeking indulgence of the court. Since so anything any instruction on your part, so that I am asking you. I am not imposing any precondition of fear because that is to be volunteered by the petitioner.
Hon'Ble brother का relation माना अच्छा तो मुझे कोई भी लॉक 2 लाख टांग maximum लॉक टांग भी कष्ट होता है.
But there is no affidavit to that effect.
आगे तो रहते देवी कोई भी देवी लॉक टांग. Your lordship may impose. Your lordship's order will be binding on me. Affidavit conduct.
My lord, he has taken 20 lakhs from me. And 5 lakhs.
Mr. Patnaik, now you are officer of the court.
I'm sorry.
Is it a recovery proceeding? So only thing is that he is being for the criminal allegations or criminal part, he is getting punished.
Yes.
That is.
So if there should be a recovery proceeding, I don't understand this. Why you are not, because you are wasting time. If there is a money claim, it will be barred by limitation. You bring out a proper case.
Your lordship's view is reflected in a Supreme Court judgment.
Yes.
That a bail proceeding is not a recovery proceeding.
Mr. Naik, I have been educated by the Slotted State Council. They have also read those judgments. They say that basically that order is not, so that order I am not passing. I understand the position of law to a certain extent. That strictly speaking, in some cases, Supreme Court has said that order cannot be passed. But then you will say Subrat Ray Sahara.
Yes.
It started with Odisha High Court. Justice B.N. Mahapatra, as then he was. That was upheld by the Supreme Court. But in some cases, those conditions have been set aside by the Supreme Court. So there is some sort of divergence. So this is not a recovery proceeding. And that money, suppose, even if deposited, that is not anyhow going to the this person, the informant or the victim. Yes. As you may say, that money, no order can be passed. That is the other limitation also.
That is
Yes, thank you. And I mean, when I wanted that answer from you, since considering your age and experience, obviously this is not a recovery proceeding.
Right.
Similar cases जोड़ा से कहिले कोर्ट सेटा कोन माने
Similar case ଅଛି ନା ନା
ठीक है जस्ट देखो तू पेज 16 रे नहीं सेट बाय स्पेसिफिक नहीं so that is why I'm asking you Page 17 देखिबे rejection order बोधे सेटा bail application 757 of 23 आपनकर running page 17 internal paragraph माने paragraph होची 6 above 6
Yes.
Deposits on the higher interest are invoked, having a bad impact on the society and robbing people in the ସେ କହୁଛନ୍ତି ଏଇ ଟାଇପର ଅଫେନ୍ସ ସବୁ ଲୋକଙ୍କୁ ନେଇକି ଇଏ କରିବା ଠିକ ନୁହେଁ କିନ୍ତୁ
there is involvement of the co-accused person and the investigation is in progress to link up the involvement of the petitioner and the co-accused person in similar cases.
ଯୋଉମାନଙ୍କର anticipatory bail pending other relations ଏସବୁ ମା ଭାଇ ଭଣଜା ସମସ୍ତେ ନାଁରେ କେସ୍ କରିଦେଇଛନ୍ତି ଓଏସ୍ ଅଫିସର ସେମାନଙ୍କର anticipatory bail ଅଛି
ସମସ୍ତ ମାନେ all are in that family.
Yes, all the accused persons are belong to the same family, one brother ନିଜ ଭାଇ ବି accused.
But this particular petitioner is not married.
Yes, ଭଣଜା ଆମ ଭଣଜା
ଆପଣଙ୍କର ମାନେ other accused.
ଆପଣଙ୍କ ଭାଇର ଭଣଜା.
No, Mr. Naik, he to that extent he's also saying that no, there is no other allegations.
No other interest.
That he's saying also that.
No other interest.
This is item 11. Mr. Dharanidhar Naik, Senior Counsel, instructed by Mr. Basanta Kumar Das for the petitioner. Mr. S.S. Mr. Mahapatra, as per your instruction, any criminal proclivity?
No, my lord, that has
As per the police report, it is not there.
Yes, my lord, that is there. No, not involved. No.
Okay.
Criminal. Yes.
I mean, they have mentioned it.
Yes.
Mr. Biswanath Patnaik, S.S. Mahapatra, AC for the state, Mr. Biswanath Patnaik for the informant. The learned counsel for the petitioner submits that the petitioner is in custody since
28/8/2023.
Because same day it was rejected, first hour, second hour.
Yes.
28/8/2023. In the meanwhile, the final prosecution report has been submitted on
That has been
preliminary.
on. Lordship,
PPR code. Preliminary prosecution report has been submitted on
23/10/2023.
Keeping the investigation open on
Yes.
173 into bracket 8 CRPC. It is further submitted that considering the age of the petitioner, he should be given a chance to come back to the social life. It is further submitted that the petitioner is a local person. He shall subject himself to the jurisdiction of the court in session of the matter.
My lord, petitioner held from Balangir.
Local, sir. Local money, not the district or from the say flight risk like a foreigner. So tripod test of bail. And outside state, in fact, they are languishing. Mr. Patnaik, the situation is really grim. Outsiders are hardly getting bail anywhere because they are unable to do anything as far as security and all that concerned. So in that context, I was saying it's a local person. The petitioner is a local person, shall subject himself to, but it's a positive direction. He shall subject, the submission is positive, not negative. He shall abide by, subject himself, and the petitioner shall abide by all the terms and conditions that would be imposed for grant of bail. The learned additional standing counsel referring to the material content in the case diary. Like what a submission add karibe, the learned senior counsel also submits that the petitioner has no past allegations of criminal activity against him. And in fact, this petitioner apana kochonti nuhanti related boli.
No. It's not related to me.
Relation, no. Direct relation.
I don't know, sir. Because he
do not know, say you do not know.
My friend.
Anyway, I will not record that. I will not record that. Kon lekhi? In fact, cutting. The learned additional standing counsel referring to the materials contained in the case diary opposes the prayer for bail. However, it is not disputed that as per the police report received by the learned additional standing counsel, there is no past allegations of criminal activity against the petitioner. Para. The learned counsel for the informant vehemently opposes the way for bail, and it is submitted that for grant of bail, a condition may be imposed regarding deposit of an amount of money. Para. Having heard learned counsel for the petitioner, the learned additional standing counsel for the state, and the learned counsel for the informant, this court is inclined to grant bail to the petitioner, subject to such stringent terms and conditions that would be imposed by the learned court in season of the matter. It is as stated on behalf of the petitioner in court today. The petitioner shall deposit an amount of 2 lakhs, which shall be. How 2 lakhs? 2 lakhs, which shall be kept in an interest-bearing account in a nationalized bank with auto renewal clause, without prejudice to any of the rights and contentions of any of the parties. Such deposit shall be subject to the final outcome of the pending trial. Then I would like to a further condition has to be shall be imposed by the learned court in season of the matter, that any violation of oblique deviation from any of the terms and conditions of the terms and conditions that would be imposed for grant of bail shall result in filing of petition for cancellation of bail by the investigating agency. Disposed of accordingly.
Urgent settlement.
Yes.
Item 12.
Mr. Vasudev Misra for the petitioner. Mr. S.S. Mahapatra, additional standing counsel for the state. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions and advance arguments as prayed for. List on 11 January 2024.
13.
Yes, please. ଆପଣଙ୍କ ନାଁଟା kindly I forgot you.
Sonali Ponda.
Miss M.S. Ponda on behalf of S. Jenna for the petitioner. You remove the defects. The defects are pointed by the SRB removed within 2 weeks. 3 weeks kar diyantu. List after vacation kar diyantu. List after removal of defects kar diyantu. Yes.
14.
Yes.
Hello, sir. I'm appearing on behalf of
Your name?
Mona Lisa Ghosh.
Miss M.S.M. Ghosh, Mona Lisa Ghosh on behalf of Jaideep Pal for the petitioner. Defects be as undertaken, defects be removed within 3 weeks.
We have tried to contact the petitioner from time to time, but he didn't respond the same, and he has not tried to call us again.
The learned counsel for the petitioner learned counsel for the petitioner submits that despite their efforts, the petitioner is not responding, and they may be accommodated further. So
We don't have any instructions.
then you have to file that memo.
Yes.
Okay. Memo dated 24/11/2024 filed by the learned counsel for the petitioner is taken on record. The notice cannot be issued by the court to the petition. That's not the procedure.
Yes,
This is nature of 138 CRPC, a 138 Negotiable Instrument Act. Or you have not seen the brief. On perusal of the judgment impugned, it is indicated that No, sorry, simply the petition was filed in the year 2012, challenging the judgment dated 12/11/2010 passed by the Learned Appellate Court, so and so like debe, in appeal so and so, confirming the judgment dated 7/11/2008, acquitting the opposite party from the charges under section 138 of INI Act in so and so case like debe, court and the case number. In view of the statement made at the bar that the petitioner is not interested to prosecute the matter, the memo recordable likhichanti. Yes. The petition stands disposed of. Yes.
15.
This is that application, my lords, of the leave petition filed by the Odisha Vigilance Plot in lordship directed this in this case regarding the well-being of that opposite party, my lords. I've got the instruction. Lords, you can peruse the date.
Passed away.
The date. Again, say instruction of them. First instruction. First. Lords, you turn to the last page as a death certificate appended.
Yes.
On the 2nd March 2015, lords.
Permitted to withdraw this amendment. It is on record actually now. Flag K is on record. Your lordships. The Learned Counsel for the petitioner has filed memo at Flag K, indicating that the petitioner doesn't want to praise the PLAPL. Earlier by the petitioner has filed, affidavit has been filed on behalf of the petitioner.
Those are regarding criminal incident.
Indicating the past allegations of criminal activity against the petitioner, which are on record. In view of the memo dated 10/11/2023 at Flag K, its date, I think the date is mistake. That is 16 or 15. What is it? About memo dated 16. Overwritten age. 15 na 16.
Not 16 till I haven't got a copy.
16 again. Memo filed on 16. Memo filed on 16/11/2023. The petition stands. Is dismissed or disposed of, Mr. Standing Counsel? Disposed of.
Disposed of.
Disposed of.
If Lordship permits, my lords.
Please.
Lords, I have submitted Lordship, this may be glanced through, my lords.
This is item?
No. This is a list of years old CRLP, which is my position. All cases, 2005, 3, 2, 20 years old, lords.
No, I hope they are listing it serially. I mean, that is my standing instruction that always go to the, the earliest case.
Because sometimes, my lord, because of these things are gathering dust.
But I have to.
Okay, now getting 2014 cases, but probably these are the cases where gathering dust. They were not inclined to remove from the old racks and all this. But if they can take some paints, my lords, it can be listed with defects also can be disposed.
I cannot.
Offhand,
I can't say that whether they are listing it. But my instruction is that they should, take out the cases, earlier ones, and gradually they are telling me that there is no further bail petitions as far as my roster is concerned. So more and more CL.
These are all CL for 2003.
3-4. I noticed that.
20 years back.
Yes.
This.
Withdrawn. Disposed of. Yes. Next. Yes, please.
My lordship.
Yes.
The petitioner has been acquitted on dated 9/11/2023.
Mr. Pradyus Kumar Padhi for the petitioner. Mr. But affidavit file korantu ni Mr. Padhi. I think I told you, don't never file any affidavit on behalf of the petition.
Memo is.
Memo dele tapore.
Memo.
Ago de dele. Na ki affidavit has been filed by Sanjulata Jena. Who is he? Who is she?
Antecedent, regarding antecedent.
Antecedent. Okay. The Mr. Pradyus Kumar Padhi for the petitioner. Mr. Standing Counsel for the state. The learned counsel for the petitioner being present at the virtual court, Odisha High Court. At Balasore addresses argument. The learned counsel refers to the memo marked as flag X, indicating that the petitioner has been acquitted by the learned trial court by judgment dated 9/11/2023 from the charges. He was facing trial. The memo date likely memo dated 22/11/2023. In view of the above, the petition stands disposed of. Yes, Mr. Padhi, disposed of?
Sir, my lord.
Yes. Next.
Item 18.
Petitioner none. Opposite party blank to grant further opportunity. List on. Sentence likhibe. None appears for the petitioner when the matter is called. To grant further opportunity. List on. 8th of January 2024.
19.
Same order. Date.
No.
9th of January.
20.
Shunandu, Mr. Barik. Now you have already adjourning matter to first 3 weeks of January. You start with 22nd January because they are not coming. Upon the pack kar deleni already. You start today. You start with 17th January.
One day, my respective submission matter will be adjourned to one day. Well, if it will be 9th or 10th,
no, there is a difficulty because unwittingly, so I am finding that 50 matters have been adjourned, 40 matters have been adjourned to one date. Because we are not that systematic in noting the.
Yes.
So it is always safe. You see, in some high courts like you see in Delhi or Punjab, no concept of giving short adjournments.
Yes.
Because you should leave space for fresh matters and all these things. Now, since the fresh matter has reduced, so that these matters are being listed.
Sorting different dates for different cases taking time. That's why
No, he should be ready. That is.
That's for that.
No, January he was not having the calendar. He said. Today I have got the calendar and provided it. That draft calendar. Calendar in the sense that High Court calendar which has been prepared.
That has been
you have got the calendar.
Yes, but that draft
calendar because unless we refer to that
1 month back we got it.
And the bail and other deferred matters should be earlier, first week, second week.
Yes.
Because there is no point in listing the matters, hearing matters. No one is responding.
Bail application for particular period, my lord. I think that may be, my lord, shifted to some other, my lord, period because since my lord has already finished up all those things, bail application, they may go for certain advance the date also. Registry may do.
Yes.
This week with ayus of.
The other aspect actually, which I have been highlighting, that if instead of adjourning matters, short adjournments in a month, we are having at least 20 working days.
Yes.
So we can, if we are listing about 100 matters every month, it comes to 2000. Then more and more matters are coming on the board. Like Mr. Das was pointing out, that 3-4 matters, no one is looking at them. Some matters now listed, I understand, these are all 2006 matters.
Yes.
So, but because there are some very active practitioners, if you adjourn their matters, they are ready. But many matters just pending and we are carrying the burden. Because no one is taking interest.
No one is.
Yes.
Item 20.
Same order. 16.
21.
Mr. 21 petitioner none. Mr. 21 Mr. Standing Counsel.
Mr. Naik, my lord.
Mr. Devasis Naik AG. Same order. Date कही चलन 16 yes
22.
22 on behalf of Mr. Panda. May kindly be adjourned. He has some personal difficulty.
I'm sorry, your name
Sonali Panda.
Miss M.S. Sonali Sonali Panda on behalf of Mr. Gyanananda Panda, J.N. Panda. For the petitioner, Mr. Devasis Naik, AGA for the state. Instruction kon asla? The instructions received from the learned additional civil judge, come JMFC, Madanpur, Rampur, dated 14/11/2023 indicates that the 1cc case number 4 of 2011 stands posted to 23/11/2023.
For what purpose, man? Because it was for framing of charge.
Mr. Standing Counsel, it is obvious that they have retrieved the file because this file after the interim order would have been consigned. Inactive, dormant file. What is that called? Dormant file.
Dormant.
So now after this letter from the High Court, now they have dug it up.
They wake up now.
Obviously, they have no choice. The proceeding
Framing of charge.
The registry shall also obtain an up-to-date status regarding the orders regarding the proceeding that happened on 23/11/2023 before the learned JMFC. Yes, sir.
Status actually
The status it is alive. It is being listed means it has not been stayed. Otherwise, you would have said that due to stay order, most likely.
Yes,
but it's not clear.
No.
It's not clear. Yes. Upon a list, January कर दिया
17.
So 17 January. Yes, next.
23.
Same order. Date कहले नहीं पड़ा.
It was adjourned for the last 3 occasions.
Yes, none appears.
It is
Where you are referring to 23.
Yes. Is confirming judgment.
So anyway, confirming judgment of acquittal or conviction?
Must be conviction.
Appeal was dismissed.
Conviction. 6 months with 65,000.
So what is the money receipt? He has received some amount, compensation. It can be closed.
That is 1,521.
Full and final settlement of 1cc case, Annex 3.
Yes, my lord.
You can close it.
That's why nobody will be.
In Mr. Pavitra Naik's case, we have done that. That is how no one is coming. The annex, the petitioner none, Mr. Standing Counsel for OP1, OP number 2 none. None appears for the petitioner when the matter is called. None had appeared when the matter was last taken up on 12/10/2023 and 18/8/2014, and it was adjourned to grant further opportunity to the petitioner. Here the conviction is and fine or fine? And fine, 138.
Yes, and fine.
The learned Standing Counsel
And to pay.
assisted the court as far as the since last is the quote, since no one is appearing on behalf of the opposite the petitioner or the opposite party now contesting opposite party number 2. Annexure 3 signed by the complainant is a receipt dated 1/5/2011. That is after the appellate court's judgment dated 5/4/2011. The opposite party number 2 has put his signature on a revenue stamp after accepting the amount of rupees 70,000.
My lord may say as it seems, my lord, because my lord has not verified the test, my lord.
A photocopy kar diyo. Photocopy.
Yes.
Annexure 3 is a photocopy. Apan ita dekho. See the physical copy, Mr. Barik.
Thank you.
Photocopy kar deythile. Because now for me everything is photocopy. Paperless. Kaun lekhile? Towards amicable settlement of the dispute between the petitioner and the opposite party.
That
the receipt also contains signature of 2 witnesses.
And the next page, your lordship may see the affidavit also there, my lord, in that regard. That will, my lord, help for
The ଆପଣ ଟିକେ ଦେଖିବେ page 23-24 କାଢନ୍ତୁ. Further, it is further enclosed as marked as Annexure 3. The affidavit, copy of the affidavit dated 21/9/2011.
shown in by the complainant.
Shown by the OP number 2 complainant. Indicating regarding the settlement of the dispute. Stating the following, page 24 re 3, 4, 5 ta quote kar debe. 24, page 24, 3, 4, 5. Para. Could you find what is the period of detention, if any?
That will be, my lord, that LCR is not there. That will. Spoon's conviction. Oh, my lord, it is not there.
Not indicated.
You are.
Here, the case the Mr. Standing counsel, just kindly look at page 1, section 138.
I don't, sorry. NI Act, I don't.
ଆଉ ଗୋଟେ ଆପଣଙ୍କର ଅଛି ପରା ସେ ସେଣ୍ଟ୍ରାଲ ଷ୍ଟାଚ୍ୟୁଟ ରୁ କାଢିଲେ negotiable instruments act.
NI Act change ହେଇଯାଇଛି.
No, this is 2022 edition.
ସେଥିରେ ଥିବ
Punishment କଣ change ହେଇଛି?
ନୂଆଟା ଥିବ ସେଇ ଏୟାର ମାନୁଆଲ ଟା ଥିବ.
One 132 last paragraph ଟିକେ ପଢନ୍ତୁ. ଆପଣ ପଢିଲେ ଚଳିବ. I will listen. ପଢନ୍ତୁ.
That 130.
Last ଯୋଉ paragraph last ପଢିବେ shall be punished. Just read it aloud.
From the beginning.
No, the last जो 132 last जो page रे last line टा sentence टा.
Without prejudice to any other provision,
Yes.
this act be punished to be punished with imprisonment for a term which may be extended to 2 years and with fine which may extend up to twice amount of the check with both. That's it.
Then
Provided that nothing contained in this section shall apply unless the check has been presented to the bank within a period of 6 months. The payer holder due to course of check as the check may
library ଗୋଟେ ପଠେଇ ଦିଅନ୍ତୁ ମୋତେ.
the drawer such fails to
ପଢା n ଦେଖିଲେ ନା ଗୋଟେ ଦିଅନ୍ତୁ ମୋତେ.
Since the settlement, my lord, it's a settlement, my lord. Go into the
ଆଣିଲେ ବେଟା
rigorous of 138.
ଏପଟେ ଯାଉନାହାନ୍ତି. You come this way. इंडेक्स आगे देखिए. इंडेक्स देखला ପରେ ତାପରେ ପାଇବେ. इंडेक्स ଦେଖନ୍ତୁ କୋଉ ଭଲ୍ୟୁମ ରେ ଅଛି. ତାର ଗୋଟେ इंडेक्स ଭଲ୍ୟୁମ ଅଛି ସେପାରେଟ. Be punished with imprisonment for a term which may be extended to 2 years or with fine.
Or with fine. That is
So it's not and with fine.
My lord, that I think that is been added in the amendment, my lord. That amendment was effective from, I think, my lord, that is after this, my lord, appeal judgment. That amendment is effective from, my lord. I think that twice of the check amount that has been inserted by the amendment.
No, I can modify that. 58 is amendment of the year 2003. But it's not, the minimum punishment is not imprisonment. It is or fine.
Or fine.
Yes, it's not and fine. ଆପଣ ଆଉଥରେ ଦେଖନ୍ତୁ ଦିଅନ୍ତୁ.
Yes. With fine. That with
No.
in default now. In default law. A compensation time now.
इंडेक्स ଟା पाइले कि whatever जेल था कि जो भी था. Volume 34 आनंद 34 35 रे थे नो. It's not and fine. It's or fine.
Or with fine.
Or with fine.
But we are finding in every case a smaller and fine.
That may be wrongly. No. When the sentence is imposed, it has to be read and fine. But the provision is or fine.
Fine is to be there because how the money will be, my lord, recovered. That's why, my lord, that
item 23, my lord.
23. Yes. Item 23.
Item 23, my lord. The lordship, case was compromised. I will obtain instruction regarding my lord whereabout because after
it is
case
for each.
वकालतनामा फाइल करिवि next week रे
36 are. That's how it is. Take, say you have compromised. What is the order? What can be the order? That's the discussion being going on. Yes. Agya cannot be the order. Agya, sorry.
Agya, sorry.
What can be the order after negotiation? It will be confined to the payment already made.
Yes.
What about the punishment that?
Punishment order, because the order is to be confirmed. Appellate orders confirming the order of conviction. So conviction remains.
Yes.
Conviction remains, but when the amount is already been paid.
general पचरा होची आज्ञा सेटा एक केस रे पचारनी मु ता नेक्स्ट वॉल्यूम टा पाउनांती तले आस बसंत in general discussion होची जे so what best order can be passed. It is well understood that it has been compromised. There is a affidavit, there is a receipt, everything is there.
Conviction cannot sustain once because the compromise can be met at any stage. Under NI Act, compromise can be even appellate stage, even in the before the Honorable Supreme Court case can be compounded. So once even compromise.
केबे आणले आपण कहबे सेटा को citation दियंतु.
Citation Lordship put on Tuesday I will say.
आज के तारीख Mr. Jafrullah you are for the petitioner.
Petitioner.
This is item
23.
Jafrullah for the petitioner submits that he has instructions to appear for the petitioner. Mr. Standing Counsel for the state.
I will also verify.
The learned appearance likely. The learned the matter was heard at some length. Is तापर आपण जोटा प्रपोज affidavit का तो लिखि दैछथि सिस्टम सब रहिला The learned counsel for the petitioner seeks accommodation to advance arguments regarding the furthest regarding the consequence of the compromise between the petitioner and the opposite party number 2. List on 12th of December.
Thank you, Lord.
Yes, next.
24.
Petitioner none, opposite party none. None appears for the parties when the matter is called. None had appeared on 16/10/2023 and the matter was adjourned to grant further opportunity to the petitioner. The petition was filed in the year 2012 with a prayer to set aside the judgment of acquittal passed by the learned trial court in ST number so and so with a judgment dated so and so. On perusal of the judgment enclosed to the petition, it is indicated that the finding of acquittal was returned by the learned trial court after examining the depositions of the prosecution witnesses and the materials produced by the investigating agency. The learned court has held that the PW1 who has been presented as a eyewitness as injured eyewitness through his statement did not support the prosecution case. The other injured witness such as PW2, PW6 complainant, and PW9 other witness injured witness PW6 and complainant PW9. According to the statements of so and so witnesses, start the sentence saying that statements of PW2 then have been dealt with by the learned trial court. In contrary opinion of this court, the finding of the learned trial court cannot be faulted with in view of the evidence presented. The petition stands disposed of. Yes, next.
25.
My lord, may kindly see.
25 somebody mentioned.
My lord, that 147 your lordship may kindly see.
Yes, please.
It's compoundable. Like NIA compoundable.
It is compoundable. It is compoundable at any stage. But why then? Why no? It was admitted. No, there is a decision of Supreme Court.
Yes.
It is compoundable at any stage. But then why after that it was filed here? That I was thinking. And how it is entertained, because that affidavit is part of the case brief.
Yes.
Receipt is part of the case brief.
Actually, it is being confirmed by the, my lord, in the appeal they have filed, my lord, all those things has been done and they have been filed with the appeal and with the revision.
So 147 doesn't say regarding at what stage it is compoundable.
No.
But Supreme Court, I think, has interpreted that at any stage it is compoundable. Thank you. Call लिखले. Next 25.
25.
Mr. Rupam Misra on behalf of BK Misra for the petitioner. Opposite party blank. The learned counsel for the petitioner seeks accommodation to advance arguments as paid for list on 12/1/2024.
26.
Same order. Date कर दियो तू. I'm sorry. 26 petitioner none. Mr. R.R. Misra for the opposite party. None appears for the petitioner to grant further opportunity. List on 18 January. Yes.
27.
Yes.
May it please your lordship.
Yes.
Your lordship, I am appearing on behalf of Advocate Subhasis Patnaik.
Your name, sir?
SP Biswal.
SK.
SP Biswal.
Mr. S.P.
Biswal.
Biswal.
Yes.
Mr. Patnaik is now an additional government advocate, I think. So
Yes,
he
sir.
cannot appear. So Mr. Biswal for the petitioner. Opposite party who is appearing? Opposite party blank. Yes, what do you say, sir?
Your lordship, we have filed this application for grant of leave to prefer an appeal.
Yes.
Under 370. Your lordship, agreed by the judgment of the special judge, Bhubaneswar.
Yes. No.
Ordered
So
it
who
to-
is appearing for the opposite party, because notice was there and notice has been issued?
Mr. Tripathi is appearing, my lord. Viren Chandra Tripathi.
Yes. None appears for the opposite party number. None appears for the opposite party. लिखी दियंतु. The list on date कर दियंतु. When do you want?
Your lordship deemed fit. Any date that your lordship may deem fit.
After. No, I am pleased today, but then the other side is not there. 10th of January.
Yes, sir. Highly.
Yes, you also obtain instruction if anything survives. That is more important.
Yes, Lord.
Yes.
28.
Yes.
Milad,
Yes, please.
I have to address to your lordship alert as to why have I come to your lordship alert in this matter.
No, since there is no time today for hearing, the difficulty is that today second half
Yes.
as a truncated.
Yes.
It is up to 2:50.
Right.
So you agree for a date?
My lords, if it is possible to give us half an hour in the post-lunch session, my lords.
No.
I may not be able to conclude. My lordship will see, my lord.
No,
I will take your lordship's indulgence to the hearing which happened during the time when the Honorable Justice Ratho was in session of the matter, my lord. It was live.
No, Mr. Das, because what he is saying that there has to be a particular slot. That I am not doing.
No, my lords, I was just requesting if it is possible today. Otherwise, my lords, I'll bow down to a date.
No,
I bow down.
Today, half an hour from 2, then I'll be. I will not be able to complete reach 54.
My lords, I bow down.
That's the difficulty.
I'll not request more, my lords. I'll bow down to that.
So when both of you agree for a date,
My lords, anything short that's comfortable
Yes,
to my learned senior and the honorable court.
Can it be 20th of December, my lord?
Yes. 20th December?
Yes, my lords, absolutely. It's 20th if it's the 21st is more convenient if it's possible.
21st I am already.
All right, my lords, 28th, no problem.
Mr. Appearance Saman Rohibo, whatever appearance is there. Since no time is left today for detailed hearing,
20th.
As agreed, the matter will be listed on 20th December 2023. The interim order as passed earlier shall continue till the next date. You said about the difficulty because of the interim order. What is the difficulty?
My lords, actually, my lords, the NCLT has to pronounce on the
proceeding.
petition. My lords,
But in that proceeding, you are a party also.
yes, my lords,
I mean-
earlier the NCLT has granted a
No,
status
because
quo.
if I remember, I suggested either you agree for because both proceedings cannot because that will not help you also. I mean, either of the parties will not benefit
My
out of
lords,
that. If
actually,
the
for that, I moved an
Because-
affidavit, my lords, what happened in the settlement meeting as to why, my lords, there has been no settlement, although the clients did meet over 2-3 meetings. My lords, the difficulty.
no, you
I'm
examine
facing-
also after this mediation code has come.
Yes, my lords.
This type of litigation, the imperative is that it should be there should be some kind of settlement. Adversarial litigation doesn't benefit anyone.
Absolutely, my lords. My lords, and those are the instructions we
And even when prior to mediation code, you have seen Reliance
Yes, my lords.
that the
And
business
my lords, the
tycoons.
difficulty I'm facing, my lords, why I keep requesting for urgency, I'm so sorry, is because
No,
my
not
lords,
at all, not at all. But
there's
I
a
wanted because I
status
think
quo.
there is no substantive status quo order, but the other proceeding is waiting.
So NCLT had passed a status quo order which I did not challenge in appeal because I thought that the final hearing was going to happen. Now, my lords, that December.
No, I offered that. I offered that you have to state that proceeding can continue without any prejudice.
No, my lords.
But
this very proceeding.
then the second thoughts and wise also. That is a no. Let it be.
When this honorable court first passed the interim order, it is very clear and candid that this interim order will not stand in the way for hearing other interim applications
My lords, actually,
which have a nexus with the hearing of this case.
Yes.
It was very clear.
my lords, actually,
And please, one
I'm so
second.
sorry.
And despite that, my lord, NCLT did not hear it. I have placed it, my lord, on 2-3 occasions. Let NCLT hear other 3 interim applications which are very much germane and directly in my lord, has a connection with this matter. My lord, even I was not to be said, it fell from the honorable court. You can move a contempt if the NCLT is not hearing the matters. And now, my lord, it is very clear. It is as clear as a whistle. Honorable Supreme Court has in fact hauled up a retired judge of the High Court who ultimately became the member of the NCLAT by dishonoring the order of the Supreme Court. He was punished and thereafter he has to resign. And when this honorable court,
he offered to resign and that matter was closed.
Yes. And when, my lord, this honorable court has given a specific direction that pendants of this application will not be a hurdle for other interim applications taken up. What was the impediment not to hear?
Let us see.
Exactly, my lord.
Actually, my lords, if I can just state something completely different from all of this, my lords, the reason why I keep pressing for urgency, my lords, deholds the new petition, which petition to be heard first. In this very petition, my lords, where the pronouncement is stated, there was an order passed that there shall be status quo as to assets. Now, my lords, I never challenged that order because I was challenging maintaining.
You are saying the status quo has been violated.
Now, my lords, I'm not saying, my lords, I have to maintain the status quo. I am in possession of the premises.
I'm in possession, not
My
in-
lords,
not us.
I went, my lords, to start the factory. My lords, the asset is a factory. It's a power plant. My lords, when I went to start the factory, it was closed for the last 2 years. When I went to start the factory, my lords, the petitioner came with the order and the police saying there's a status quo. My lords, we withdrew from starting the factory. Now, my lords, now the final order is not pronounced because of the stay by this honorable court. That December order, my lords, in NCLT continues meanwhile. Now, my lords, I am in a position where I'm not able to earn my livelihood. And this company and this factory is the only. That's why, my lords, I've moved an application in that regard. If I can be permitted to rent out the factory and carry out maintenance.
Your preposterous
I'm
submission.
This is my submission.
Jory, actually, the difficulty is that in adversarial litigation, this is the disadvantage.
Yes, my lords. That's why, my lords, I am not even pressing to debate. I just wanted to explain.
Let us see on
my-
20th.
Please, my lords, I'll be highly obliged.
Yes. Same order, 20th. Jahan aapke appearance hole, 20th. Same order.
14th will be difficult. So 15th, if it is possible. So 14th, actually, there is a specially fixed matter for physical hearing in Delhi.
No, that will be 20th. Oh, no, sure.
20th.
Great. Highly obliged, my lord.
Yes.
Interim order continue.
Yes, yes. Interim order to continue. As passed earlier, shall continue till the next date. Yes.
Extremely grateful, man.
Yes, please.
29.
29, Milord, that NAFRA matter, Milord. Milord, I need to get some instructions from my client.
And the difficulty of time constraint.
Yes, yes, Milord, that's why I'm praying, Milord.
For me, it is easier. I'll just go back. You have to go there and have your food and come back.
Yes, Milord, no, what I was suggesting,
So
Milord,
date, please agree.
30th.
But Prabhu is prevailing every day.
No,
so
no,
yes,
30th. No, we decided 30th, Milord. Ja Prabhu ka ichha.
Ja Prabhu ka ichha hai. That way. So 29th is same appearance kar debe. 29 list on 30th. Since not much time is left for hearing the matter. List on 30/11/2023.
All three matters.
All three matters.
29.
Appearance are saman rahega. One is Prabhu, the other is Bhokta, the other is I think
Marana, Mr. Marana.
Mr. Marana.
Milord, sir, I'm
Item
filing my
30.
appearance.
Same order.
Cost type.
31.
Same order.
Grateful, man.
Yes. So we'll resume at 2 again. Sorry? Sorry. Sarditile. Sardavata, ठीक है?
My lord, hearing matter.
No, no one will be there, I know.
Yes.
Apart from the mentioned matters. That is how actually, though I tried to give an impression, even the 100 item will be heard, but somehow the things are not falling into place.
Yes.
I mean, when we start the day,
Yes.
at least any learned counsel should feel that even the 100 listed, that will be heard. But somehow things are not working that way. Purna matter interest padalani sabu.
Yes.
Yes, Mr. Das.
I crave your lordship permission Milord, to reiterate my submission, Milord, the old matters.
Yes, yes,
Milord,
old matter,
and an endeavor we made.
Yes, yes. But I can't assure of now because I have given them.
Not necessarily perfectly. At least some endeavor should be
Let us
made.
see what is happening.
This has to be resurrected because of
Mentioned
20 years
that.
back cases.
Mentioned that.
35.
Sir, Tukuna Kumar Misra for the petitioner. State 35.
Mr. Kanon.
Sir, SS Kanon go EGA for the state. The learned counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for list on 12/1/2024.
41.
Mr. Jira Nada Bulioli. Sunandini. S. Sunandini. On behalf of S. Behra for the petitioner, Mr.
Naik.
Devasis Naik, AGA for the state, the learned counsel for the petitioner seeks accommodation to obtain instructions as prayed for list on 12/1/2024.
45.
Mr. R.K. Pradhan for the petitioner, Mr. Mr. S.S. Mahapatra, AC for the state, the learned counsel for the petitioner seeks accommodation to obtain instructions as prayed for list on 18/1/2024.
50.
Mr. Same R.K. Bhuya on behalf of R.K. Pradhan on behalf of L. Bhuya. Same as 45.
Myself, mine.
50 रख लेना. Mr. Standing Counsel. Opposite party Standing Counsel.
52.
Mr. P.K. Malik on behalf of Satyajit Mahapatra. S. Mahapatra for the petitioner. Mr. Standing Counsel for the state. The Learned Counsel for the petitioner seeks accommodation to obtain up-to-date instructions as prayed for list on 16 January 2024. Your matter, Mr. Misra?
My lord, I pray for adjournment only. Item number 34, 37, 38.
Mr. R.R. Misra, 34. 34 private opposite party. Or you are there also. State is UP1 or pro forma. 34 Mr. R.R. Misra for the petitioner, opposite party blank. The Learned Counsel for the petitioner seeks accommodation to obtain instructions. As prayed for list on 19 January 2023. I'm sorry, 24. 19/1/2024. Then Mr. 37.
37 and 38.
37, 38, same as 37 the state.
37 is state Mr. Naik, 38 Mr. Mr. Kanungo, 38 Mr. Naik.
37, Mr. R.R. Misra and Mr. S.S. Kanungo. 38,
Mr. Naik.
Mr. R.R. Misra and Mr. Devasis Naik. So both the matters, upon date, same date,
My lord.
Same date. 19/1/2024. Any other matter? Because all those who are not present, that will go out of the list. Any mention? Upon date kar debe.
54 was mine. Further accommodation may be given. 54.
Sir, your video is not coming.
My video is not coming. I am using my juniors. Suddenly, I noticed that your lordship is taking up the matters. So I could not.
No, I am not taking up. If you are interested, you can come and argue.
No. I have written a letter, so I need further accommodation.
I have no problem, sir. I have no problem. Till at least 250, I am there.
Okay.
Earlier hearing matters have now collapsed. So both hearing matters, read petitions have collapsed, and so that is how.
Waiting for Mr. Nanda. Mr. Nanda is not visible. Unfortunately.
No. I have a problem. If 54 is adjourned,
the voice is familiar. Mr. Santosh 54 lekhan to Mr. Santosh Kumar Nanda for the petitioner.
Myself.
Bracket invisible. Mr.
Myself.
Mr. Standing Counsel for the state. The Learned Counsel for the petitioner seeks further accommodation to obtain up-to-date instructions and from the petitioner as prayed for list on 22/1/2024.
obliged, my lord. Obliged.
Yes. Any other matter, any date, anyone, if he wants for any date, so the court master will give that.
Thank you.